Welcome back to the Global Business Channel, and thank you for joining me. In this video, we'll explore the concepts of par value and no par value shares. First, we'll define what par value is. Then we'll delve into the meaning surrounding the concept of no par value. After that, we'll discuss how par value shares are relevant to both private and public companies. Similarly, we'll visit the topic of no par value shares. And finally, since I operate within the financial services sector in Mauritius, we'll review some of the significant provisions of the Mauritius Companies Act 2001 concerning par value and no par value shares. I hope you find this video informative, and as always, I encourage you to engage in a reflective and insightful viewing. So, what is par value? What does par value mean? Par value, also referred to as nominal, face, or original value, represents the stated value of a company's share ownership, or the value specified on a share certificate. This value is typically outlined in the company's constitution, articles of association, or memorandum of association, depending on the company's registered jurisdiction. In some cases, share certificates for purchased shares display the par value. If it does not, then it means that the share is of no par value. It serves as the minimum legal price at which a company can issue its shares. The terms par value, face value, and nominal value are often used interchangeably to denote the stated value of a company's share at the time of issue. Certain jurisdictions mandate that companies establish a par value below which shares cannot be sold. To comply with such regulations, most companies set a minimum par value for their shares. This ensures that shares cannot be sold at a price lower than this established value during subsequent issuances, thereby reassuring investors and shareholders that fair pricing standards are maintained. Companies issue shares to generate equity, and those issuing par value shares often do so at a value that may not align with the actual market worth or financial standing of the company. This adjustment enables companies to mitigate their contractual obligations, as par value establishes a binding agreement between the organization and its shareholders. In essence, par value signifies the fixed and printed value of a company's share, which remains constant. So, what is no par value then? As you may have guessed, no par value is exactly the opposite of par value. It means shares issued without specifying a par value in a company's legal documents or on a share certificate. Nowadays, most shares fall into the category of either no par or low par value shares. The price of no par value shares is determined by what investors or shareholders are willing to pay, often decided by the board of directors or outlined in the company's internal documents, or based on the company's financial status. You might wonder why a company would choose to issue shares with no par value. Firms do this to avoid potential liabilities to shareholders if the company's financial situation worsens. No par value share certificates do not specify a face value. Sometimes, smaller companies seeking to limit their number of shareholders may opt to issue shares with a face value, meaning par value, of $1 for accounting purposes. If you are enjoying the content of this video so far, I'd really appreciate it if you could post a like on the video and perhaps even subscribe to the channel, as this would help my growth with the YouTube algorithm and analytics to reach a wider audience. Lastly, if you would be interested in being a sponsor of the next video for 30 to 60 seconds, feel free to email me at theglobalbusinesschannel@gmail.com to discuss further. Now, back to the video. Companies issue shares to raise equity capital. Therefore, multiplying the par value by the total number of shares issued, in Mauritius referred to as outstanding shares, gives the minimum amount of capital generated when all shares are sold. The par value of shares used to be printed, and still is to this day, on the front of paper share certificates, and is often accessible digitally. In practice, companies typically set the par value at the smallest feasible amount, often just 1 cent or up to $1, as required by law if and where applicable. This minimal value is crucial because the par value of shares establishes a legally binding agreement between the company and its shareholders. If shareholders pay less than the par value for a share and the company later defaults on its financial obligations, creditors cannot sue shareholders to recover unpaid debts exceeding the purchase price. This legal protection stems from the separate legal personality of a company limited by shares from its shareholders. Typically, shareholders' liability for the company's debts is limited to any unpaid amount on their shares. What are no par value shares then? No par value shares differ from par value shares by not having a fixed nominal or face value assigned to them. Instead, their worth is determined by market dynamics such as supply, demand, and the company's capital needs or financial performance. This means that these no par value shares can be sold at prices either above or below a nominal value, which would otherwise be the par value. One significant advantage of no par value shares is the reduction in legal and administrative costs associated with issuing shares with fixed nominal values. This is because there's no need to pay stamp duty based on that value, although this may vary depending on the tax laws of each jurisdiction. For instance, in Mauritius, under the Land Duties and Taxes Act of 1984, land transfer tax is imposed on land transfers at a rate of 5%. Similarly, shares of a company owning immovable property in Mauritius are subject to a 5% land transfer tax, based either on the value of the shares or the property, whichever is lower. However, certain transactions, such as transfers between companies within the same group, or transfers for the sole purpose of merging, are exempt from this tax. No par value shares are appealing to investors and shareholders due to their flexibility in pricing, allowing them to buy shares at fair market prices. This facilitates investment in companies and helps companies attract investors and shareholders more easily. For startups in particular, no par value shares are advantageous as they enable them to raise capital more effortlessly. Startups often struggle to raise funds due to their lack of establishment and track record. No par value share capital allows startups to set share prices based on market demand and specific financial needs, simplifying the capital raising process. Now let's briefly review some of the legislative provisions regarding par value and no par value shares in the context of company law. As I operate within the offshore global business sector in Mauritius, we'll be discussing the Mauritius Companies Act 2001. However, it's important for you to refer to the specific legislation governing companies in your jurisdiction. I won't be reciting the exact sections of the Companies Act, but instead, I'll be simplifying the information for better comprehension. Feel free to pause the video before each section is discussed so that my explanation aligns with what you are seeing. Let's start with Section 47 of the Companies Act 2001 regarding no par value shares. Subsection 1 states that any shares established or issued following the initiation of this act, meaning post the year 2001, will be shares without a designated par value. meaning shares of no par value. This is applicable to domestic Mauritian companies, which are not offshore companies. However, global business corporations and authorized companies are exempt from this provision. This is confirmed in Part 1 of the 14th Schedule of the Act, which states, number 1, despite Section 47, a company holding a global business license or functioning as an authorized company may choose to issue shares with or without a specified par value, as long as all ordinary shares or all preference shares of the company adhere to one type. This means that the company cannot issue a set of ordinary shares at par value and a similar set of ordinary shares of that type at no par value. Each type and class of shares must carry the same par or no par value. Number 2, if par value shares exist, they can be denominated in multiple currencies. Subsection 2 stipulates that unless specified otherwise in subsection 3, the par value shares of a company already registered under the Mauritius Companies Act 1984 or the Mauritius International Companies Act 1994, when this act began, will maintain their par value status. The par value of the shares will remain the same as before this act commenced. Subsection 3 in turn states that any existing company mentioned in subsection 2 can convert any class of its shares into shares without a designated par value at any time, under the condition that A, all shares of a specific class consist of either par value shares or shares of no par value. If all shares of a company, number 1, are of the same class, the conversion must be approved by a special resolution or by written consent of 75% of the shareholders. Or number 2, comprise multiple classes. The conversion must be approved by the holders of each class to be converted by a special resolution or by written consent of 75% of the holders of that class. And C, notice of the conversion terms is provided to the Registrar of Companies for registration within 14 days of the conversion approval, outlined in paragraph B. Regarding subsection 4, despite what is stated in subsection 1, a company mentioned in subsection 2 can, after this section begins, meaning section 47, issue shares or specific classes of shares with a set par value, meaning par value shares. Next, with subsection 5, after the notice is registered according to subsection 3C, the shares mentioned will, with the exception outlined in subsection 6, be considered converted into shares of no par value. Continuing with subsection 6, the conversion of shares under subsection 3 won't change the rights and responsibilities linked to those shares. Specifically, this means A, any outstanding payments due on the shares, and B, the rights of the shareholders regarding dividends, voting, repayment during liquidation, or a reduction of capital will remain unaffected. Subsection 7 implies that despite what is stated in subsection 1, the Registrar of Companies has the authority to grant an exception if A, a company, whether registered or proposed for registration under the Companies Act 2001, is a wholly owned subsidiary of a company registered outside of Mauritius, and it is necessary for the company to have shares with a set par value for its reporting obligations abroad. Or B, there are valid reasons for issuing shares at a specific par value. In such cases, the registrar may, subject to subsection 8, allow for the issue of a specific class or classes of shares with a par value. Lastly, a dispensation under subsection 7 will be given based on terms and conditions determined by the Registrar of Companies. It is important to note that all shares of a particular class must have a set par value, and any premiums received from issuing shares must be moved into the share premium account, as outlined in section 48.5. So that wraps up today's video. Thank you for staying till the end. Your support is truly appreciated, and I hope you found the information useful. If you enjoyed the video, hitting the like button would mean a lot and also helps with the YouTube algorithm. I'll keep sharing informative content regularly, so be sure to come back for more videos on offshore, global, and financial services. Take care, stay safe, and I'll see you in the next one. Cheerios, guys.